Seated.
Mr. Lukic.
Da.
Thank you, Your Honors. I will have several comments to make on the submissions we've just heard from our learned friends with regard to the final submissions, the closing arguments of the defense. I would first like to express a position of the defense that Ms. McKenna referred to, namely whether the structure and the chain of command of the Army of Yugoslavia had anything to do with the assistance provided and the provision of the officers' corps, which in their view has to do with effective control and Article 7.3 with regard to Mr. Perishic's responsibility. We don't share the view of the prosecution at all. We think that the prosecution may have neglected the indictment itself, because there in paragraphs 29, 30 and 31, where an aspect of aiding and abetting is referred to on the part of the Army of Republika Srpska, and considers all the individuals mentioned in these paragraphs as subordinates of General Perišić, and explain the underlying position supporting his command responsibility in relation to them. In that context, what we said about the membership of the army and the superior-subordinate relationship and whether anyone was within or without the VJ, all of this is relevant to establish responsibility under 7.1. If for nothing else, then for their allegation of atmosphere of impunity. Now, let me address what Mr. Thomas had to say in relation to my yesterday's words, namely the provisions of the of the law on the Army of Yugoslavia. I referred to those provisions, as did he, and you yourselves, Your Honors, will have to examine them in your assessment of the evidence. The law on the Army of Yugoslavia, as all of us here in the courtroom are well aware, and as Mr. Thomas mentioned a moment ago, does not provide for the possibility of dispatching VJ personnel to a different country. This was something that witness Starčević testified about, and it is something you heard the positions of both parties on. You also heard the words of General Perišić at a meeting of the Supreme Defense Council when he discussed the possibilities under the law at the time he was within the Army of Yugoslavia. The law on the Army of Yugoslavia regulates something else that I discussed, as well as what Mr. Thomas mentioned, and I agree with. An officer of the Army of Yugoslavia, and please look at Article 7, which provides for the composition of the Army of Yugoslavia, who it is who makes up the Army of Yugoslavia. And now I'm referring to the law. Under that law, an officer of the VJ can be assigned within the Army of Yugoslavia and outside it. The provision of the law that both I and Mr. Thomas referred to deal with the status, rights and obligations of the VJ officer who is within the VJ and outside it. The law is quite precise in relation to the Ministry of Defense and in relation to what I invoked, the regulation of the various aspects of the service, appointment, promotion, and termination of service. This has been stipulated very specifically in relation to the Ministry of Defense because there is a certain hierarchy within the Ministry of Defense. We heard witnesses Nikolic and Starčević on this issue. For this reason, the law on the army, which regulates the status of the VJ personnel within the MOD, is very specific. An officer of the VJ, such as Starčević and Nikolić, who were seconded to the MOD, they were as such outside of the chain of command of the VJ and within the hierarchy of the MOD. However, their service and their status within that service is regulated as if they were members of the VJ. When an officer of the VJ is, for instance, assigned to a special purpose industry, he will not be taken out of the VJ chain of command, but simply because special purpose industry doesn't have its own chain of command. That's what the law states, and that's why they don't have specific provisions referring to them as the MOD does in Articles 151, 158, and 181. So we have a situation whereby the law does not provide for the possibility for an officer to join a different army, and we have the status which is related to the Ministry of Defense and which is specifically envisaged under the law. This particular situation could not have been envisaged by the law simply because the law does not stipulate that their personnel can join an army in a different country. Simply such a scenario was not envisioned. This was the reason why fictitious virtual documents had to be drawn up on appointments to a different army, something that does not exist in essence. But as we were submitting, they are leaving the chain of command of the VJ simply because they've entered the chain of command of a different army, and simply because you cannot have two chains of command functioning. At transcript page 10532, witness Starčević spoke about what the actual state of affairs was, given that the law itself did not envisage the possibility for someone to join the ranks of a different army. All of the submissions we made in relation to the provisions of the law indicated how someone in relation to the MOD, when it came to appointment, transfers, termination of service and promotions, and specifically disciplining, all of this is outside of the VJ when the individual is within the Ministry of Defense, including disciplining. Let's make it simple. For instance, I, as a VJ officer, joined the Ministry of Defense, where I committed breach of discipline. It is only within the authority of the Minister of Defense to initiate disciplinary proceedings against me under the law, and not General Perišić or anyone else from the army. Once I returned to the ranks of the Army of Yugoslavia, where I'm assigned to a specific duty, from that point on, General Perišić or the individuals as regulated by the Army's service rules have the authority to initiate disciplinary proceedings or whatever actions against me. This is the submission by the defense. You have the OTP position with relation to the law, and they know themselves, because we've been dealing with these facts for the past 2 years, that this is something that was not envisaged by the law. I will not be invoking all the other provisions of the law. I will merely say that this is our interpretation of the law. Mr. Thomas presented us with their interpretation of the law. The two parties, however, do agree on one score, and that's that under the law, it was not envisaged that a VJ officer may be assigned to a different army. What the OTP did not mention, and this is something that we've been discussing for the past 2 days, first, in relation to aiding and abetting by the provision of the officers' corps and through active actions by General Perišić, i.e. the setting up of the personnel centers. This particular officers' corps was given vitality which enabled them to exist as such. We challenged these OTP submissions, but received no response whatsoever. Your Honours, the army is not an ambivalent, disorganized mass. Every army is a structured organization which has particular posts occupied by certain individuals. This is what makes up the chain of command, and that's how the army works. It is our submission that these individuals, whilst they were within the 30th and 40th personnel centers, and via those in the Army of Republika Srpska and the Army of the Serbian Krajina, were not within the chain of command of the Army of Yugoslavia. And I will not dwell on this point any longer. There is one other topic I'd like to address. I'd like to make two brief comments and then I'll finish, and they have to do with what Mr. Harman mentioned a moment ago. They have to do with the sanctions imposed by the FRY after the rejection of the contact plan, group plan. I think that the rebuttal in this sense went beyond the scope of our discussions, but still I have to address the comments he made to the effect that the sanctions imposed by General Perišić were not honored. First off, what we mentioned above all in relation to political leaderships and the relationship between the Army of Yugoslavia and the leadership of the VRS and SVK is something that we presented in relation to influence and control, in relation to the existence or non-existence of a superior subordinate relationship, which you need to establish in order to establish command responsibility. The defense never contested, and we even invoked these documents. This was earlier on in private sessions. We're in public session now, but we can say that the Federal Republic of Yugoslavia, despite the fact that it introduced sanctions upon Republika Srpska in August of 1994, a certain while later resumed the provision of assistance to both the VRS and the SVK, as well as to both these countries, the RS and the RSK. I'll remind you that we showed these Supreme Defense Council decisions from May and June of 1995 to witnesses, and especially after Storm, when it was said quite decidedly that assistance to the RS would continue in view of the general situation which posed a threat to the stability of the FRY, insofar as it may pose a threat to its combat readiness. That's what the decision said. And we take no issue with the statement by Milosevic, which Mr. Harman referred to, that this assistance was continued. We submit that it did not continue throughout the existence of the sanctions, that the Army of Yugoslavia consistently enforced these sanctions insofar as it concerned the powers of the VJ, until such time as the SDS ordered that assistance should be provided again.
Sorry.
SDC, interpreter's correction.
Thank you.
Zahtev da ispravim sam.
Yes, we wanted to correct that part of the transcript.
Stranica 65, red 2.
Page 65, line 25, I said Supreme Defense Council. SDC.
SDC. Okay, you may proceed, Mr. Lukic.
Evo kad sam stao stranica.
Now that I've stopped, let me make a small correction. Page 63, line 4, I said witness Nikolić, not witness Starčević at that point.
Pomenuo je
Mr. Harman mentioned the exhibit which had to do with the loan of 500,000 dinars that General Perišić gave to General Mladić. Those were two documents. One was Perišić's and the other was Mladić's letter.
Mr. Harman characterized it as a loan. I do not.
Dobro, ako...
Very well.
Samo sekund, molim vas.
Bear with me, please. Then I misinterpreted him. I used the term loan because that was how the amount was characterized in one of these two documents. So my apologies to Mr. Harman, but that was also the testimony of witness Petrović. And, as you will see, one of the two documents used the term loan. Bear with me for a moment, Your Honor.
Da ne bi bilo zabune u pogledu.
To avoid any confusion with regard to the defense's position on this issue, in paragraph 365 of our final trial brief in relation to the loan of 500,000 dinars, we expressed what our view was in relation to the loan. We assert that at the time, the defense minister, Pavle Bulatović, was privy to that loan and even discussed it. You have it in footnote 658 of our trial brief, where we refer to one of his statements in the minutes 572, page 89. That's minutes of the Supreme Defense Council.
Zahvaljujem, poštovani sude.
Thank you, Your Honors. If you have any questions, I'm prepared to answer them. But these were the comments that we wished to make in relation to the prosecutor's rebuttal.
Thank you very much, Mr. Lukic. It remains for the chamber just to thank the parties for the conduct of the trial from the beginning to now. We've now reached the end, almost. And pursuant to Rule 87A, the rules of procedure, the chamber declares the hearing closed, and the chamber will retreat to go and deliberate, and parties will hear judgment on a date to be determined. Court adjourned.